So students, welcome to the first SIAC, that is Singapore International Arbitration Center, and the Center of Alternate Dispute Resolution of Jindal Global Law School's Emergent Issues in International Commercial Arbitration. Today we have with us Mr. Kevin Nash. Kevin, yes, so Kevin holds a BA from Mount Allison University. Just a minute, Kevin. There's a problem here. Okay, so Kevin holds a BA from Mount Allison University and JD from Osgoode Hall Law School. Kevin worked as one of in Canada's prominent 7 sister law firms, and then went on to study an LLM in international commercial arbitration from Stockholm University. So Kevin has been in the SIAC since 2012. He has managed more than 1,000 international cases under all versions of the SIAC rules, namely the SIAC 2012, revised rules 2013. Then you had the SIAC investment arbitration rules of 2016, and of course the SIAC 2016 rules. So he has significant experience in SIAC cases. So today the topic is, today he's going to talk about expedient arbitration, about the expedient process. And now I give the ground to Kevin. So welcome, Kevin. The floor is yours.
Thank you very much for having me. It's my great pleasure to be able to speak here on behalf of SIAC. I would encourage all of you to ask questions as we go, because this is really an important issue. We titled it as the need for speed. So why does arbitration need to be fast? Why are users choosing arbitration increasingly? If we look at the Queen Mary Whiten case study, arbitration is far and away the preferred mechanism for resolving cross-border disputes. And speed is quite a big part of that, because speed, and there's a direct relationship between speed and the costs of arbitration. So if you go to the first principles of arbitration, why are parties choosing arbitration? So faster, more cost-effective, the ability to choose your decider, to customize your procedure, and this is relevant in terms of these procedural tools, limited avenues of appeal, and then of course enforceability under the New York Convention. It raises some important issues on the role of an institution. So if we know that our parties are choosing arbitration because it's fast and cost effective, how fast should an arbitration be? Because it will depend to a certain degree on the colors and the contours of any case. So if you have a 5 billion USD multi-jurisdiction, multi-party dispute in relation to a dam or a power plant, and it's a 3-member tribunal, this case might take a little bit longer, and it should take a little bit longer. By opposite token, if you have a relatively simple small value dispute, then the parties may want to be able to get to a decision as quickly as possible. The way I look at it from an institutional standpoint is that the institution should make sure that the arbitration is exactly as quick as the parties want the arbitration to be. Where users sometimes get frustrated in arbitration is that when it takes longer than anticipated from the institution side, or if the tribunal is set to render an award and it takes months for them to render this award. It also informs the choice between institutional arbitration and ad hoc arbitration. Ad hoc arbitration traditionally has been very popular in India. So this is an arbitration that is not under the auspices of any institution. So it will be in accordance, say, with the Indian Arbitration and Conciliation Act. The parties likely have selected the governing law of the contract, and it proceeds without this institutional referee, if you like. In institutional arbitration, in addition to the rules, you also get the supervision of the institution. The institution is there to make sure that the arbitration proceeds expediently and in accordance with the parties' wishes, and really the bargain of the parties, because this is why parties have selected institutional arbitration. So we're going to be looking at expedited procedure, emergency arbitration. I'm sure that many of you have seen emergency arbitration in the news, particularly recently, and this feature called early dismissal. So I'll start with Singapore's international arbitration framework. Many of you are going to go on to disputes practices, or you might be corporate lawyers, and you're going to be drafting these arbitration clauses. And as you would all be aware, because party autonomy is king in arbitration, parties can customize the clause in whatever way they want. And there are many different laws that can be at play. So you choose the seat of the arbitration. This is the legal home of the arbitration. So in SIAC arbitrations, parties will often choose Singapore as the seat of arbitration, but because we have so many Indian parties selecting SIAC arbitration, you also see SIAC arbitrations where the seat, this legal home of the arbitration, might be Delhi, Bombay, Chennai, Bangalore. It's completely up to the parties. Parties will also choose the governing law of the contract. This is how the tribunal is going to decide on the substance of the dispute. And there's some recent case law that maybe makes it prudent to also select the governing law of the arbitration agreement. As you would be aware, the arbitration agreement is separable from the main contract. So you can have a different law governing the contract, the substance of the dispute, and then a different law that's governing the existence and validity of the arbitration agreement. Referencing that same Queen Mary Whiten case study, this is really the seminal survey in arbitration. Singapore is now tied with London as the most popular seat of arbitration in the world. And Singapore has been very intentional about creating a very hospitable environment for arbitration. And there's a lot of components to this. The idea in Singapore, what we want to do here is to be able to resolve any kind of dispute. So you have international arbitration, but international arbitration is so much bigger than just SIAC. You have 6 major institutions all administering cases out of Singapore. So you have SIAC, ICC, the Permanent Court of Arbitration, WIPO, ICDR, which is a branch of the American Arbitration Association, and the Singapore Chamber of Maritime Arbitration. These are all institutions administering cases out of Singapore. And then even though I will be espousing the advantages of institutional arbitration, you also have a fairly robust ad hoc arbitration regime in Singapore, particularly for domestic cases. So that's the international arbitration piece. There's also international mediation. I'm sure many of you would have seen the Singapore Convention that provides for the enforceability of mediated agreements. So we have the Singapore International Mediation Center, which is a sister organization of SIAC, and we have an ARB-Med-ARB protocol with SIMC. One thing that we've noticed at the institution is parties are increasingly using tiered clauses. So from a drafting standpoint, parties may decide that they want a specific period of negotiation or mediation, maybe expert determination, adjudication, to happen before the arbitration. So what ARB-Med-ARB does is it commences an arbitration, you constitute the tribunal, then the arbitration is stayed, it's put on hold, and then the parties attempt to come to a mediated agreement. If they are able to come to a mediated agreement, then they go back to the tribunal, and the tribunal is able to put the settlement of the parties into a consent award, and now you have the enforceability under the New York Convention. So you can enforce this mediated agreement that's in the form of a consent award in 168 countries across around the world, save for those limited exceptions that we see in the New York Convention. So mediation and arbitration are starting to go hand in hand quite a bit, and particularly with the relationship between the Singapore International Arbitration Center and the Singapore International Mediation Center. And then we also have the Singapore International Commercial Court. This is for international litigation. And this is the Singapore International Commercial Court is comprised of Singapore jurists and then a bench of international jurists. And this is important because when you're choosing the seat of arbitration, you're choosing the supervision of the courts. And the Singapore International Commercial Court is a division of the High Court. So if you have an arbitration seated in Singapore and you need relief from the courts for a certain reason, what you can be very confident in is that the Singapore High Court is one of the most pro-arbitration courts that we have in the world. It has been held that there is an unequivocal judicial philosophy of the facilitation and promotion of arbitration. Arbitration has firmly taken hold in Singapore, and this is why many parties choose Singapore as the seat of arbitration. There's also a lot of soft factors that go into why parties would choose Singapore as the seat. Back before we entered this COVID-19 period, and now most hearings are being conducted remotely, the reality is that Indian parties were very comfortable coming to Singapore. The same way that I used to like always going to India, Singapore or Indian parties would like to have their hearings in Singapore. It was a comfortable place for them to go. The way that I look at the Singapore regime is that everything just works in Singapore. You have very prominent local law firms and international law firms all practicing international arbitration in Singapore. You have modern, best-in-class legislation. You have experts, funders, independent arbitrators, all of these in a very cohesive arbitration community. And then it's also just very easy to get to Singapore and to operate in Singapore. The tradition of Singapore, I look at Singapore to a certain degree as kind of being like Switzerland in Southeast Asia. Everyone knows that when they come to Singapore, the rule of law will be applied without fear or favor. And the test, if you're an international party, say you're an Indian party with a dispute against a Singapore party, what Singapore has been able to do is that Indian party is very sure that they are going to get a fair adjudication of their case in Singapore. So that's the Singapore disputes regime, and this will figure prominently in our discussion about expedited procedure, emergency arbitration, and early dismissal. Now let's look at where SIAC sits in this mix. In that same Queen Mary survey, SIAC is now the second most popular institution in the world, behind only the ICC. SIAC, to a certain degree, is kind of an interesting experiment because now we're the second most popular institution in the world. We had more than 1,000 cases in 2020, starting from just 2 cases in 1991. So it's been an enormous period of growth. I've been at SIAC for 10 years. When I started, I believe that we had 4 legal counsel. Now we have 14 legal counsel, and particularly because so many Indian parties use SIAC arbitration, that we always now have multiple sets of Indian qualified legal counsel in the Secretariat. When we've been designing the rules and we were discussing the different iterations of the rules, so we're currently in the 6th edition, the SIAC rules 2016, and we've been continuing to refine these procedures to make arbitrations faster and more cost effective. So you can see an evolution of these different procedures. And what we're able to do is we're able to say we're currently in the process of a rules revision right now. So early dismissal, for instance, we've had 5 years of experience with early dismissal. We're able to see what works, what doesn't work. And then for the next set of rules, we're able to then codify that into the rules. If you're thinking about the life cycle of an arbitration, particularly an institutional arbitration. So us at the Secretariat, we get a notice of arbitration. Say it's from an Indian claimant against a Malaysian respondent. There's 16 of us lawyers in the Secretariat, so I might assign this to an Indian qualified legal counsel. Maybe the case is governed by Indian law. We commence the arbitration, ensure that all the requirements for the notice of arbitration under the SIAC rules, all of these requirements have been met. And then before the tribunal is constituted, this is where a lot of the action is. So it could be emergency arbitration or expedited procedure, joinder, consolidation. A party on the respondent side could say, well, I haven't signed this contract. I'm not a party to this arbitration. I don't want to have anything to do with it. I object to the competence of SIAC over me to hear this case. And this is all matters and elements that happen before the constitution of the tribunal. Much of the institutional work is done before you get the tribunal appointed. Once the tribunal is appointed, and it's the tribunal that will hear early dismissal applications, once the tribunal is appointed, the tribunal is the master of the arbitral proceedings. The institution takes a step back and save for administrative matters such as collecting deposits to ensure that the fees of the tribunal and the institution are secure, or maybe challenges to an arbitrator. The institution doesn't really do that much. Where an institution SIAC then figures again is at the end of the proceedings. So very few institutions have what we call the scrutiny of awards. So the scrutiny process, any award in an SIAC arbitration before it is issued is reviewed by the institution. SIAC and ICC are the 2 main institutions that do this. What we're doing there is we are looking to enhance the enforceability of the award. It's not a case where the tribunal submits the draft award to the institution and the institution is out to change the tribunal's mind. We don't have to agree with the decision. And in most jurisdictions, you cannot try to set aside an award or resist enforcement on the award because the tribunal decided wrongly. So we're just making sure that all the procedural requirements have been complied with, and we're anticipating where is this award going to be enforced. Staying with the example of the Indian claimant and the Malaysian respondent, our initial presumption would be, okay, if this Indian claimant is successful, this award will likely be enforced in Malaysia. So what are the requirements for enforcement in Malaysia? But when you're counsel in an arbitration, before you as an Indian claimant even start an arbitration with your counterparty, you're going to want to go through an asset tracing exercise to determine where this Malaysian counterparty might have assets, because you may not have to enforce it in Malaysia. This counterparty could have assets in Singapore, India, the United Kingdom, so you may have multiple options for enforcement. And the good news about arbitration, and particularly in SIAC arbitration, is that you won't have to go through an enforcement process most times. In most cases, after an award is issued, the parties will voluntarily comply with that award, and you won't have to go through the enforcement proceedings. So let's move on to expedited procedure. In expedited procedure, I will have to restrain myself from talking about it too much because it is one of my favorite topics in all of arbitration. Expedited procedure, what it is at its core, is a fast-track mechanism to get an award as quickly as possible. So under the SIAC rules, you can apply for the expedited procedure and you have an award rendered 6 months from the constitution of the tribunal. In a typical SIAC arbitration for a sole arbitrator tribunal, that might take 12 months. For a 3-member tribunal, it might take 18 months. So this can be a significant advantage if you need an award quickly. Parties sometimes in the arbitration clause will be able to customize procedure to make it a fast-track procedure without going through the exercise of applying for the expedited procedure. Now, my view on arbitration clauses is you need to be really careful when you're drafting arbitration clauses. I have seen an arbitration clause where the parties want the award fast, but they're not sure what the dispute is going to look like, say, 5 years after the contract, after this transaction is consummated. So I've seen arbitration clauses that provide for an award to be rendered 7 days from the constitution of the tribunal, or 120 days from the constitution of the tribunal. Because you have these procedural mechanisms ensconced within the body of the rules, if your arbitration clause contains a reference and incorporates the SIAC rules, you don't have to contract for anything specifically in the arbitration clause. You have the option to apply for the expedited procedure under the SIAC rules. So for expedited procedure, there's 3 general formulations. You can have a separate set of rules, fast track rules or expedited rules. This is the position taken, say, by the Kuala Lumpur Center, Stockholm. So at the time of the transaction, you have to decide on the expedited procedure. So this is at one pole. In the middle, you have institutions such as SIAC, the Hong Kong International Arbitration Center, where you can apply for the expedited procedure. So it's the same set of rules, and you can apply, and this will often be a contested application. And then I guess at the other end, you have institutions with automatic application. So the ICC is a good example with this. So after 1 January 2021, any dispute under USD 3 million is automatically streamed into the expedited procedure unless the ICC court decides otherwise. So looking at SIAC by application in the main body of the rules, and you can apply for the expedited procedure under 3 heads. So you can apply on the basis that the amount in dispute is under 6 million Singapore dollars, on the basis of party agreement, or in cases of exceptional urgency. Most of the action is on the basis of the sum and dispute. So the sum and dispute is under 6 million Singapore dollars, and then usually the claimant will say, this is a very simple case. There isn't going to be a requirement of expert witnesses, fact witnesses. We think is appropriate for the expedited procedure. The respondent may contest this application, and the respondent might say, well, wait a second. No, this is actually very complicated. The facts are in dispute. There's complex legal issues. We want the ability to be able to call fact witnesses, expert witnesses. We don't think this is appropriate to be able to run in 6 months. One of the most important issues in expedited procedure, and this is really because of the construction of the SIAC rules, is whether a sole arbitrator tribunal or a 3-member tribunal is to be appointed. So under the SIAC rules, the president of the SIAC Court of Arbitration, Gary Bourne, has the discretion to appoint a sole arbitrator, even when the arbitration clause contains contrary terms. So what this means is if the arbitration clause says 3-member tribunal, a party can still apply for the expedited procedure. And if they do, then if the president decides, a sole arbitrator is going to be appointed. There are conflicting judgments on this. There are 2 judgments in Singapore that says the president indeed does have this authority. And then the Shanghai Intermediate Court in a case called Noble Resources said that the president was not able to appoint a sole arbitrator. So the Singapore decisions are a case called AQZ and ARA, and then a decision of the Singapore International Commercial Court called BXS and BXT that says that the president does have this authority. I should say, with full deference to the Shanghai Intermediate Court, I'm not sure if that's really a pronouncement that says the president does not have this authority, because there's been a case under similar circumstances that was enforced in Ningbo, but it's something to think about. And it's particularly interesting, I think, from a statutory interpretation standpoint of how an express term agreed by the parties is going to interact with an incorporated term. If parties in an SIAC arbitration don't want to have a contested application, they can also agree on an expedited procedure model clause. We do see that from time to time. And if any of you are interested, I was sitting with the Singapore delegation in UNCITRAL Working Group 2, and this is where we're now almost finished. And there's now, for the UNCITRAL rules, there is going to be expedited rules for UNCITRAL, and it's going to follow the construction like Stockholm and Kuala Lumpur, where the parties have to expressly agree to the application of the expedited rules. And this is primarily due to the ad hoc nature of the UNCITRAL rules. SIAC administers cases under the UNCITRAL rules, but in most situations, the UNCITRAL rules are ad hoc. So 3 different ways to apply in SIAC arbitrations. The amount in dispute is under 6 million Sing on the basis of party agreement and in cases of exceptional urgency. These are just threshold requirements. So even if you have a case that's, say, 500,000 Singapore dollars, the president in his discretion may choose to not apply the expedited procedure. And there's very good reasons for this. And having seen many hundreds of these applications, I can say that quantum does not always correlate with complexity. You can have a very small value dispute, even a $5,000 dispute or a $10,000 dispute that we see from time to time, that is wholly inappropriate for the expedited procedure. And then you could have higher value disputes that are able to get done in about 6 months. So the threshold requirement of the amount in dispute is just a way for the parties then to submit on whether or not it's appropriate. It would seem relatively simple to be able to judge the party agreement. So whether by way of the clause or post-dispute, I think most often post-dispute, the claimant in its notice of arbitration might propose that the expedited procedure should apply and invite the respondent to agree. And then the respondents might say, yeah, actually, we want an award quickly as well. We agree to the application of the expedited procedure. Things can get a bit more complicated if the agreement is set out in the arbitration clause. Now, if it expressly says the parties hereby agree to the application of the SIAC expedited procedure, then that's no problem. But what if it says that the parties agree that the arbitration should be conducted expeditiously? Is that an agreement to the expedited procedure? And so then there could be an argument on the sufficiency of the agreement, where the claimant might say, yes, we have agreed to this. And then the respondent will say that, no, this was just a general agreement that the parties should conduct the arbitration expeditiously, but there is no agreement specifically for the SIAC expedited procedure. And then the third head, exceptional urgency. There's not too many applications made under exceptional urgency, because if you look at all the sets of institutional rules around the world, there really isn't a very good definition of what exceptional urgency means. The way that I look at it in the cases that I've seen, what this means is urgency on the merits, that there's something happening, say, 7 months from the time of the filing of the notice of arbitration or the commencement of the arbitration, that whereby the party needs to have this award in 6 months. It could be if there's declaratory relief, if there was going to be a corporate reorganization where it is clear that there is urgency. but this is urgency on the merits. So distinguishable, say, from emergency arbitration, where this is relief that is not intertwined with the merits. If you look at, and I hope that you do, or maybe after this lecture, if you look at the SIAC rules, I think that, so Rule 5.1 sets out the ways that you can apply summon, dispute, agreement of the parties, or in cases of exceptional urgency. Then Rule 5.2 is important because it sets out the procedure to apply. One aspect that I don't see too often, and hopefully when you're all very successful arbitration lawyers, you will use it. You can see from Rule 5.2 A that the registrar is able to abbreviate any time limits under these rules. Where that might be relevant is when an application is predicated on exceptional urgency. It may be that the tribunal needs to get up right away, so the registrar might abbreviate the time limit for a response. Typically, this would be 14 days, but a party could apply to abbreviate that 14-day timeline. And same thing for this 6 months for the award to be rendered. Now, 6 months, this is the accepted time in virtually every set of institutional rules, save for the Swiss chambers and I think Stockholm, where they have it even quicker in 3 months. But in most sets of institutional rules, it's 6 months. But a party could also apply for the award to be rendered in 5 months or 4 months, but we don't see that too often, but that is available under the rules. Rule 5.2b, as I mentioned, this is an important and I think very interesting element, is whether the president has the ability to appoint a sole arbitrator unless he determines otherwise. So that means that SIAC is able to have expedited procedure before a 3-member tribunal. Now, you can imagine that when you're trying to get an award rendered in 3 or in 6 months, it can be difficult with a 3-member tribunal. But I think a bit easier now that we're operating in the remote space because of the challenges brought on by COVID-19. It used to be the case if you had, say, one arbitrator's in Bangalore, another's in Hong Kong, and the other one's in San Francisco, particularly if you needed to have a physical hearing, that could be difficult to get done in 6 months. We have done it successfully, I think almost every time we've had a 3-member tribunal, but it does bring on some additional challenges. And just from a cost perspective, part of the reason why parties choose expedited procedure is that 1 arbitrator is much cheaper than 3 arbitrators. It's going to be 3 times as much for 3 arbitrators. So it's cheaper and perhaps a bit less complex to have a sole arbitrator. 5.2c is important, and you can see the language has been drafted very carefully. And it sets out that the tribunal may, in consultation with the parties, decide if the dispute is to be decided on the basis of documentary evidence only, or if a hearing is required. Now, this is why the seat of arbitration matters. Again, so the Singapore International Arbitration Act incorporates the model law. And so under Article 24 of the model law, if a party requests a hearing, the tribunal is pretty much bound to have a hearing. So that's why it's framed as consultation with the parties. The tribunal would put it to the parties, ask the parties if a hearing would be required. And if you have the claimant saying, no, this dispute should be decided on the basis of the documents, because if you do not require hearing, it's going to be even faster and cheaper. But the respondent might say, no, we think a hearing is required. We will be denied due process. There'll be natural justice issues if you do not let us canvass our case in an oral hearing. And in those circumstances, typically the tribunal would have a hearing. 5.2d sets out the timeline of 6 months from the constitution of the tribunal. And then 5.2e says that the tribunal will state the reasons upon which the award is based in summary form, unless the parties have agreed that no reasons are to be given. As I mentioned, we are right now in a drafting exercise for the next edition of the SIAC rules, and subject to the better discretion of the SIAC Court of Arbitration, I'm certainly proposing that we remove this summary form. I think what's happened as arbitration becomes more complex, even at levels under $6 million, is that expedited procedure awards are functioning as a full award. A summary form award is not really a term of art, and it's undefined, because we know under the model law that any award, reasons have to be given, or the parties can agree that no reasons are to be given. There's not really an in-between there. So summary form, I think, is done to imply that this does not have to be a very long, complex award, but it doesn't really have an attachment or ground to any principles. So to me, an award is reasoned. It doesn't have to be really, really well reasoned, but it does need to be reasoned, or the parties can agree that no reasons are to be given. Rule 5.3 was introduced in the SIAC rules 2016, partly to do with the decision in Noble Resources, where the Shanghai Intermediate Court took issue with the president's discretion to appoint a sole arbitrator, even when the arbitration agreement provided for a 3-member tribunal. So what we wanted to do in Rule 5.3 is remove any doubt that the president does have this authority. And you can see from the language there that the proceedings conducted under the expedited procedure, the rules and procedures in Rule 5.2 will apply even when the arbitration agreement contains contrary terms. Rule 5.4 allows the tribunal, in consultation with the registrar, to decide that it's no longer appropriate to have a case conducted on expedited procedure. Now, what happens as a matter of practice is, say, 6 months from the constitution of the tribunal, if it's 5 months and 29 days, and the tribunal is about to render an award. So under Rule 5, we have the power to extend the time, but what this Rule 5.4 does, if early on in the case, it becomes clear that this is not a case that should be fast-tracked, then the tribunal would likely canvass the positions of the parties, see if they think it should still be conducted in accordance with the expedited procedure. And if it's clear, if the case has become more complex, then they can apply, or in consultation with the registrar, the tribunal can say, yeah, this case should no longer be under the expedited procedure. So this 5 months and 29 days example, because if an award is rendered outside that 6-month period without an extension, then from a New York Convention standpoint, which governs the enforceability, this worldwide enforceability effectively of arbitration awards, it could be the case that a party could resist enforcement on the basis that the arbitral procedure was not in accordance with the agreement of the parties, because the parties have agreed that the award is to be rendered 6 months from the constitution of the tribunal. So let's assume that all of these factors are in place at, say, under $6 million, the Indian claimant applies for the expedited procedure. How does the institution decide? And this is one of the things that we're trying to do in institutional arbitration, is give more insight into institutional decision-making. We do that sometimes by transmitting reasoned decisions, whether it's an objection to jurisdiction to the institution, or in the case of expedited procedure. So I think it's important to let users know how institutions are deciding. And so sometimes in my capacity as deputy registrar, I might be deciding these applications. So what I would look at as a starting point is, what is the overall complexity of this case? Can we preserve and guard due process for both sides? Can it fairly be done in 6 months? Are there complex questions of fact and law? Are there any issues of jurisdiction? Are there multiple parties on one side, some of them being non-signatories, where you know that the tribunal is going to have to deal with jurisdiction as a preliminary question, or perhaps the jurisdictional issues are intertwined with the merits, but this is going to create an extra layer of complexity. One challenge that we have, because an expedited procedure application is made prior to the constitution of the tribunal, is figuring out whether or not this case fits under the expedited procedure. So it could be the case that the current sum in dispute is 5 million Singapore dollars, but it seems like there's more damages to come, and that within a few months, this might be a $50 million case. You could also have a respondent, if there's a $5 million claim, that says, well, wait a second, we have a $5 million counterclaim as well. And so then it would be outside the limit. As I mentioned, of course, you're going to look at whether the facts are in dispute. Is there going to need to be fact witnesses, expert witnesses? Where are these witnesses located? What is the language of the arbitration? The contractual documents, are they all in one language? Is the case suitable for documents only? This is where arbitration is at its most efficient, or do we think that a hearing will be required? And sometimes you have to be looking at it from an overall fairness standpoint. If the arbitration clause provides for a 3-member tribunal, maybe it's necessary for a 3-member tribunal to adjudicate this case. So we could have expedited procedure with a 3-member tribunal, or we could decide that it's not appropriate, and then it's just a 3-member tribunal under the regular proceedings. And then I guess ultimately we're looking and trying to have a sense of where is this going to be enforced, this award ultimately. One of our charges that's set out under the SIAC rules is that we need to effectively best efforts to ensure the enforceability of the award. So we want to take that into account as well. Since the expedited procedure provisions were introduced on 1 July 2010, we've had 670 applications with 388 of those applications accepted. So of those 670 applications, so it's about a 60% success rate. These would all meet the threshold criteria. So you can see that SIAC is quite judicious in deciding to put a case on expedited procedure, because even if all of the qualifications are met, it's still around 60% of the cases that are going to be fast tracked. So that's expedited procedure. Let's look at emergency arbitration. Emergency arbitration, I'm sure that all of you have heard about because it's in the news constantly, because the Indian Supreme Court just handed down its decision in Amazon and Future. I'm going to do my best not to talk about that case. I mean, it is a matter of public record, but it still could be an active case at SIAC. So I'm going to try to steer away from that, even though it is one of the most interesting issues in arbitration right now. Now let's look at why these emergency arbitration procedures are important. So if you've drafted an arbitration clause, you've chosen arbitration rather than the courts. So before emergency arbitration, if you needed urgent interim relief prior to the constitution of the tribunal, you would then have to make an application to court. But there could be situations where the court is not able to grant the relief that you need. It could be extremely urgent. Often it's an old joke in arbitration, but these emergency arbitration applications typically will happen on the eve of a holiday or very late on a Friday night. And it could be the case that the confidentiality is crucial. Now, what's happened in Singapore is Singapore was one of the first jurisdictions in the world to provide for the enforceability of emergency arbitrator orders. And this touches on the decision in Amazon to a certain degree. So under the Singapore legislation, emergency arbitrator orders or awards are enforceable as though they're an order of the High Court. So this is for both arbitration seated in Singapore and foreign seated arbitrations. You can take this emergency arbitrator's order or award and have it enforced as though it's an order of the High Court. Now, depending on the jurisdiction, and this is one of the challenges of emergency arbitration, and emergency arbitration moves really, really quickly. So Friday night, you make an application for the appointment of an emergency arbitrator. SIAC, we may appoint an emergency arbitrator in the middle of the night, early on Saturday morning, very quick timelines. But depending on what kind of relief you've sought and where the relief needs to be effected, if that jurisdiction is not provided for the enforceability, then you're somewhat reliant on voluntary compliance because it may be challenging or difficult just from a timing standpoint to be able to take this emergency arbitrator's order and go to the faraway court where you need the relief. So it's a really big legislative development in Singapore to have the enforceability of these emergency arbitrator awards. If you look at the International Arbitration Act in Singapore, this is designed to work complementary, applications to court or an emergency arbitrator. So the language used in the Singapore International Arbitration Act is if the tribunal or the institution is unable to act effectively. So if you needed, say, relief against a non-signatory, a third party, or ex parte relief, where you don't have to notify the other side, you can then make that application to the Singapore courts. But it's not a case where you can forum shop. There's a seminal case from the UK called Gerald Medals, where a party was attempting really to try to have its cake and eat it too. So applying to the London Court of International Arbitration, failing, then trying to apply to the English courts. That's not how it's designed to work. And the language in the Singapore International Arbitration Act makes it quite clear that if the institution is not able to act, then potentially an application can be made to court. Now, we have seen a lot of different types of orders. We've had 121 applications for the appointment of an emergency arbitrator. And I think Singapore overall, because we have these 6 major administering institutions, Singapore has probably done more emergency arbitrations than any other jurisdiction in the world. And what's been quite heartening for me to see is how Indian parties are getting more and more familiar with these emergency arbitration provisions. So we've seen all kinds of relief sought. A very common one would be if there was a call on a bank guarantee, say on a Monday morning. Then the party makes an application for the appointment of an emergency arbitrator. That emergency arbitrator is appointed on Saturday. The emergency arbitrator then may issue a preliminary order to restrain the call on the bond that is happening on Monday morning. We've seen lots of freezing orders, Mareva injunctions, an order against the shipyard, or order against the shipyard from interfering with the safe departure of a vessel where the cargo was deteriorating, orders for delivery up of documents, anti-suit injunctions restraining a party that has commenced litigation contrary to the arbitration agreement, and there's a public gag order. Now, when you're deciding whether to go to an emergency arbitration or going to court, if you want to choose emergency arbitration, one of the interesting questions is, what is the standard of relief that the emergency arbitrator is going to apply? Will the emergency arbitrator use local court standards? Will they use, say, Article 17 of the 2006 model law, or will they use this transnational test? Now, I think the majority of commentators, including SIAC's president, Gary Bourne, suggest that the transnational test that is really drawn from a case called American Cyanamide, that is going to look at the urgency of the request, whether there's a prima facie case, a good arguable case, the balance of convenience, irreparable harm, whether or not the harm is compensable by monetary damages. This is the trend in international or arbitration for emergency arbitration, is that this transnational test will be applied. We've also had some interesting scenarios because we do so many of these emergency arbitrations with the interaction of other procedural tools. So if we look at the 3 procedures that we're talking about here today, expedited procedure, emergency arbitration, early dismissal, you could have all of these in one. So you could have an emergency arbitration where you apply for urgent interim relief, you get that interim relief. So maybe it's a status quo injunction where the emergency arbitrator is just granting an order that keeps everything the same until the tribunal is appointed and they can deal with that request a bit more fully. They could discharge the request, amend the order of the emergency arbitrator. So everything is just staying the same. I think it's also important to look at the different standards that apply for a status quo injunction and a mandatory injunction. So most emergency arbitrator orders, these are going to be status quo injunctions, keeping everything the same. Mandatory injunctions, when you're telling a party to do something, is a bit different, and it's likely that there could and should be a higher standard for that. But when I'm explaining emergency arbitration to users, this idea that it's just keeping everything the same, and then also the additional element in the SIAC rules that if the tribunal is not constituted in 90 days, this emergency arbitrator order will lapse. So it's not really that coercive, that it's just preserving things as they are, constituting a tribunal, and then letting the tribunal deal with it. But as everything becomes more complex in international arbitration, as I was saying, so how is it going to interact with the other procedural tools? So we know you could have an emergency arbitration, then expedited procedure, and then early dismissal. But what about in cases of multiple parties, say joinder or consolidation? So we've had cases where you might have a suite of 5 contracts, an separate arbitration agreement in each one of those contracts. In order to avoid having to apply for the appointment of 5 emergency arbitrators, we've been able to have the SIAC court, which is the decision-making body for SIAC, take an urgent decision on consolidation. So this applicant for the appointment of an emergency arbitrator first makes an urgent application for consolidation. If that application is granted, these 5 separate arbitrations are then collapsed into a single arbitration, and then a single emergency arbitrator can be appointed in those consolidated proceedings. Same thing with joinder. Joinder is used when you want to add a party to a case, or a party wants to intervene or join a case, say if you had a situation where the applicant has urgent relief against multiple parties, but say there's a principal agent relationship on the respondent side. So one of the respondents is a non-signatory. We've also been able to take an urgent application for joinder to the SIAC court. What's been helpful during COVID for us with emergency arbitration is the fact that Schedule 1, where the emergency arbitrator provisions are housed in the SIAC rules, expressly contemplates 4 virtual hearings. And that has kind of been one of the challenges during COVID-19, is whether or not the institutional rules expressly allow for hearing by video conference, and then the applicable law in the jurisdiction. So the emergency arbitrator's order or award has to be rendered in 14 days. It usually happens much quicker. When I first arrived at SIAC, people would physically be running through the office. We had a bell that we would ring when we got an application for an emergency arbitrator's order, but the timelines do move very quickly. We've done so many of these that our processes are quite refined, and we appoint an emergency arbitrator in less than 24 hours, regardless if it's a weekend or a holiday. What I find very compelling for India as an arbitration jurisdiction, in addition to the Amazon case, some of the most important judicial pronouncements on emergency arbitration are coming from India. So you have a case called HSBC, Raffles Design, Hotel Mumbai, and now Amazon. These are all cases from the Indian courts that are making pronouncements on emergency arbitration. If you look at SIAC's annual report, you can see how parties from all around the world are using emergency arbitration. So for Indian parties, what I like to see is that you're getting more Indian claimants that are applying for emergency interim relief rather than being on the respondent side. As I said, we've had 121 of these applications. We keep streamlining the provisions in each set of institutional rules. So this was introduced in the SIAC rules 2010, then SIAC rules 2013, then 2016, and we're working on some new features for the next set of the SIAC rules. Early dismissal. So I'm a Canadian lawyer. You are all Indian law students, Indian lawyers. So we're common law lawyers. So we're quite familiar, say, with summary judgment and striking out from common law court procedures. But early dismissal, which effectively allows these common law litigation tools, this was really something that was used in investment arbitration. So we borrowed quite heavily from Rule 41 sub 5 of ICSID. So this ICSID where you're having investment arbitrations under the Washington Convention. But what we did is we tried to update it to the commercial space. So we were the first major commercial institution to include this in our rules in 2016. And what has been very fun is now that you look at all the institutions, because it became quite popular, they're now including it as well. So we took Rule 41 sub 5 of the ICSID rules, but we updated it. For ICSID, it's just the early dismissal of a claim, and it's time bound for 30 days from the constitution of the tribunal, and on the basis that the claim is manifestly without legal merit. So we took away that 30-day requirement, and we allow for the early dismissal of a claim or a defense, which is important, on the basis of 2 grounds: that the claim or the defense is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. Now, if any of you are looking through the SIAC rules, you might see this manifestly outside the jurisdiction of the tribunal and realize that there are potentially 3 avenues for jurisdictional objections under the SIAC rules. And if you've come to that conclusion, I can tell you that you are correct. There is effectively 3 bites at the cherry. Because of this, what we wanted to do was to make it a 3-stage test to avoid potentially an application on the eve of a merits hearing for early dismissal, because it doesn't have that 30-day from the constitution of the tribunal time bound. So the tribunal first decides whether the application is allowed to proceed, and then the tribunal determines the merits of the application if they just decide that it is going to proceed. Importantly, particularly if you're discussing the early dismissal of a defense, I think that makes somewhat anyone is a bit skittish about saying that there's no good defense to the claim. So that's why it's important that SIAC has this scrutiny process. So we're reviewing these awards, including an award that might be striking out or dismissing a claim or a defense. What I found quite interesting is because this comes from investment arbitration, you can see some of the jurisprudence from ICSID arbitrations. And so what is the standard, this manifest standard? So we know you can apply on the basis that the claim or defense is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. But this unruly horse of manifest, what does it mean? So you see in SIAC arbitrations that they're borrowing from the investment jurisprudence. And often there's a case called Transglobal Petroleum and Hashemite Kingdom of Jordan that talks about this manifest standard. And it's something that is clear and obvious that can be determined with reasonable dispatch. The exercise may be complicated, but it should never be difficult. So this is the manifest standard. Now, how does this work in practice? This has been particularly important for us during COVID-19, and this is part of the reason why we've been able to administer more cases than we ever did, because there were a lot of force majeure claims. Now, it's very easy to see during COVID, when we've got lockdowns all over the world, how you could just have a simple case of non-performance where both parties were acting in good faith. And you might have the respondent who was supposed to pick up the product that just said, well, we were in lockdown. No, we couldn't. So force majeure. And then everyone starts rummaging through the contract to see, okay, well, what does the force majeure clause say? Does it include a provision, say, for a global pandemic? So now the facts aren't in dispute, which is a perfect case for early dismissal. And it's just a question on what force majeure says. So is this claim good or bad in law? So this has been very helpful for helping to guide parties through the COVID-19 pandemic, this early dismissal procedure. Now, I think that everyone would agree that tribunals have the inherent power to determine claims at an early stage when they're ripe for determination. What we wanted to do by including the express provisions on early dismissal is perhaps give the tribunals a bit more backing, because you have to think about when you're drafting rules, to a certain degree, you are drafting for the enforcement court, because we're not entirely sure where these awards are going to be enforced. So rather than a court determining the inherent powers of the tribunal to determine claims at an early stage, which I think is very well accepted, but if you have it expressly set out in the rules, I think it is a bit safer. And we've noticed that early dismissal is becoming much more popular because of that. I also think there's an advantage when we're talking about the need for speed. How do we make arbitrations faster and more cost effective? Because by virtue of having this provision, now a party, say with a speculative claim or a claim that is wholly without merit, there is a very easy way to apply to strike out this claim. And I'll give you, say, a common example. Say you have a meritorious claimant that has a $5 million claim, and it's a relatively small company, and they're up against a very well-heeled respondent, a major multinational corporation. This well-heeled respondent may come back with a $500 million counterclaim, and say that $500 million counterclaim is including heads of claim that are squarely outside the four corners of the arbitration agreement. Arbitration is a creature of contract, so this arbitration agreement governs. And so if you have, say, many of these claims, 9 out of 10 claims are outside the arbitration agreement, the claimant with only a $5 million claim that is a small company, and bearing in mind the parties have to pay deposits towards the cost of arbitration, rather than each party paying their share for these much higher costs, the claimant can apply to strike out those 9 heads of counterclaim that are outside the arbitration agreement, rather than dealing with it for 12 months or 18 months or even 6 months. What was interesting when I was working in the UNCITRAL working group too, because the working group was looking at SIAC's experience on expedited procedure and early dismissal in particular. And the question was, can you have an application for early dismissal within the confines of an expedited procedure? And this doesn't happen too often, but our answer for Singapore to the excuse me, to the working group is, yeah, you can. What you want to avoid is a trial within a trial. So if you have a 6 months timeline for an award to be rendered under expedited procedure, and then 60 days for early dismissal, it can be a bit complicated. But again, we have noticed this streamlining effect. Let me just close with a bit of discussion about costs, because emergency arbitration, expedited procedure, early dismissal, costs are paramount. And there's really two different formats for costs in institutional arbitration. So you have a situation like at SIAC, where the costs are based on fixed fees. We have a schedule of fees where effectively you just input the amount of the claim, and then you know the maximum fees allowable to both the institution and to the tribunal. You know this at the outset. So I like that from a certainty standpoint. You know your maximum cost exposure. Other institutions operate on the basis that the tribunal is remunerated on an hourly basis. And this will typically be the situation in an ad hoc arbitration in India. Now, having done a few thousands of these cases, what I can say is that these fixed fees, not all the time, but very often tend to be cheaper. I think there's this idea that an ad hoc arbitration is cheaper than an institutional arbitration. And I'm not sure that that is the case. Part of the challenge with ad hoc arbitration, because you don't have this institutional referee, is that these can go on for years. There's very famous stories about an ad hoc arbitration with no institution supervising that might go on for 10 years or 12 years. And then if you also think if there's going to be an enforcement piece, and that after you get your arbitration award, you may still have to go to enforce it, or a party may apply to set aside the award at the seat, this can take a very long time. So this ability, say with expedited procedure, to get an award in 6 months, and the fact that you have the tribunal's fees and the institution's fees within that 6 months are already certain. The maximums are already specified. This can be a really big advantage for parties. And I think particularly in this new era of arbitration, parties are even more cost sensitive. So I really like conversations like we're having tonight, particularly because we're doing a rule revision. I think your views and your opinions on these provisions and how they function, the rationale behind them, I think that makes us better. Because one thing that I've tried to do when I've been at SIAC, and this is really the philosophy of Singapore, is to listen to what all the stakeholders are saying. When we were drafting the SIAC rules 2016, some of the best comments that we got were from law students. And I wish we could have like a list of credits, because I look at some of those provisions and I can remember the law student who on his or her own initiative wrote in to say, well, what about this? We've noticed a problem here. And that makes our rules better. So that's why I'm absolutely delighted to be able to have this conversation with all of you today. And I'd be certainly happy to take any questions.
So thanks, Kevin, for your most wonderful presentation. I received some questions in WhatsApp, and students can also ask questions here. So Ankush is asking me, so can we have a clause to opt for applicability of SIAC rules to arbitration and to have seat of arbitration in India, say in Delhi? If the seat of arbitration determines the applicability of jurisdiction courts, whether Indian courts can decide the matter on applicability of SIAC rules. I suppose, of course, that can happen.
Yeah, that can happen, and it does happen. Our second most frequently selected seats in SIAC arbitrations behind Singapore would be seats in India, and then you would have the supervision of the Indian court. So if there was an issue of jurisdiction that the tribunal decided and a party thereafter contested that and wanted to do it to the courts, it would be to the courts in India.
So I have another student question. So Kevin, you had mentioned about the ICC Singapore and its effect on arbitration. So can you just, like our students only vaguely know about this court. So how does this make Singapore seated arbitrations better? Like Singapore already had a very efficient judiciary, like what the plus points it provides from an arbitration point.
Sorry, did you say the presence of ICC?
Yes, I mean the International Commercial Court, not ICC.
Yeah. Sorry, Singapore International Commercial Court.
Yes.
Okay, so I can remember in 2014 when the Singapore International Commercial Court was announced, everyone was worried that this would be the end of arbitration. that international litigation and international arbitration would cannibalize each other to a certain degree. And that has not been the case at all. The presence of the Singapore International Commercial Court has been a huge boost to the arbitration ecosystem in Singapore. So if you think about it as a foreign party, notwithstanding that the Singapore High Court is the most pro-arbitration court in the world, maybe you just feel better having a bench of international jurists. So for me as a Canadian, we have our longest serving former Chief Justice is on the Singapore International Commercial Court. You have Justice Misra is on the Singapore International Commercial Court. So the legislation has been clarified to make clear that you can make an application to have your arbitration related matter heard by the Singapore International Commercial Court, or it might be transferred from the Singapore High Court.
Okay. Another question our students are asking, I mean, this is actually a compendium of various questions. This is the gist that I can find. That why does this idea of emergency arbitrator, expedited procedure, why are they originating? Where are they originating from, since they are neither part of the New York Convention nor part of the model law? So what is their background?
I think it's being generated from the initial idea of arbitration, that you might have elders in a clan thousands of years, hundreds of years ago, or thousands of years ago. This is supposed to be quick justice. I think what happened about 10 years ago is that arbitration was starting to become very time consuming and very expensive. And that is the idea of arbitration, is that the parties can customize this whole process. It's supposed to be fast and cost effective. So when I look at all of the new provisions that institutions are putting out there, it's not really changing anything. It's trying to get back to these fundamentals. So every time we have a new provision, it's trying to get back to these core ideas of arbitration. And certainly two of those features are speed and cost effectiveness.
So is it coming from litigation, or are we incorporating them more for, say, ICSID or similar kind of systems?
There's a bit of, yeah, that's a good point. There is a bit of that. And you see that with early dismissal, borrowing these common law litigation tools, same thing with consolidation and joinder. And I think this happens between institutions as well. And I think there's a question for the international arbitration community. Do we want convergence or divergence? Do we want predictability where all the institutional rules are very, very similar and they might start looking a lot like litigation? Or do we want there to be choice for the parties where they can choose, because we like this feature at this institution? And I'm not sure that I have the answer to that. I think kind of the answer, and I'm saying this kind of in jest, is what happens is that everyone is afraid to be first. Institutions are very risk averse. One thing that we struggled with, because we were the first commercial institution on early dismissal, because you don't know how it's going to operate in practice. So you have all of the best minds in the world of the SIAC court, the SIAC secretariat, but what's this going to look like? And so that's why typically what you'll see, and including with SIAC, one institution introduces a provision, a year later, another institution will introduce a provision that looks a lot like that, perhaps with minor adaptations. And then that's how things keep evolving, and they're the same, but also kind of different.
Okay. So there is also a question from Anushka, but before I come to that, I'll ask a question by one of my litigator friends who just left because he had a hearing, I think. So his question is very interesting. He is questioning the very rationale of it. So you see, if parties agree to an emergency, to an expedited procedure, it's all fine and good.
Yeah.
But if they do not, arbitration as such has internal mechanisms to take care of a delay, like in a sense, an intentional delay or even an unintentional delay. You can have an interim relief, you can have adjust in cost and interest, you can do various things.
Yeah.
So what is the need to have an emergency procedure if the parties are not expressly agreeing to it? And is it not like trying to force somebody into a sports car where all he wants is a city car to travel here and there?
That's a great question. I think the main advantage would be certainty, because he's quite right in that the party, you could, without making an application for expedited procedure, as soon as the tribunal is constituted, you could be making submissions to the tribunal to try to accelerate the procedural schedule. I think that the concern there is that particularly with very sophisticated respondents, they may be able to delay the proceedings. What this 6-month timeline does is that everyone is aware once this is granted, we have to get this award out in 6 months. So somehow we're going to have to get together and figure this out, tribunal in consultation with the parties. But he's quite right. And I think that there are sometimes tactical reasons where you wouldn't want to apply for the expedited procedure. The anticipated place of enforcement, we're not sure how they're going to look at this expedited procedure. The arbitration clause says this, we're going to be a bit careful, and we're just going to see if we can accelerate it by submitting to the tribunal on the preferred procedural schedule going forward.
So I will just, he had another question, but I'll just take Anushka's question here. This is asked typically like an Indian lawyer. So her question is, what if somebody misuses the EA procedure, like takes a vexatious order just to delay the time? Like what could be the trade-off for that?
Yeah, so that you'll notice from the SIAC rules 2013 to the SIAC rules 2016, there was a change from shall to may. So in the 2013 rules, it says that the emergency arbitrator shall initially apportion the costs in relation to the application for emergency interim relief. And now it's may. So when I'm reviewing these emergency arbitrator orders, my suggestion is always to leave this to the tribunal, because the tribunal at the end of the proceedings, when they're determining costs, can decide on, okay, so how are we going to apportion the legal costs and the cost of arbitration? So an application that is granted that ends up being discharged by the tribunal when constituted, and circumstances and information comes to light that makes clear that this was clearly a vexatious application that incurred a lot of costs on both sides, that will likely inform the tribunal's eventual and final determination of the cost of arbitration.
Okay, so the basic response is that the tribunal will take care if it's misused. But this brings us to the case that the Indian Supreme Court decision, we don't have statutory backing for this, but you tell me if you agree with me, but what the court actually did, it just filled up the gap. It treated as if it was the Singapore Act and treated it similarly that the Singapore Act would treat it, though the statutory language it does not support it. So Kevin, what would happen if somebody comes and like follow-up question, takes a EA order and then never comments the arbitration at all or does not participate in it? So what is the effect of that? You don't seem to have any outcome under the Indian law. What would be your understanding of this matter?
So in 90 days, that order would lapse.
Huh.
So if you had a claimant that got a successful order and then the tribunal's never constituted 90 days, that order expires. So I think.
So this is the point. They have not read it under Section 9. They have read it in Section 9. You get the 90 days thing.
Yeah. No, this is not under Section 9. This is under the SIAC rules. So are you contemplating? Yeah. Are you contemplating?
Yes. So under SIAC rule, 90 days the order is going to lapse. Then what happens? Then you have to come back to the supervisory court for assistance.
Assistance in which way? Because now you have this order that is standing there, and you want to discharge the order.
Yeah, the order has lapsed, but you have not commenced arbitration. You've taken the order, taken the tactical advantage of it, and then taken off. So what next?
So depending on, if you still have one party that's around, I think what you would do there is you would constitute the tribunal, and then the tribunal is formally going to terminate the proceedings under Article 32 of the model law, assuming a Singapore seated arbitration. And you could, but it is actually an interesting question, because what happens if you have, claimant gets the successful order, vexatious order, but they were successful on it, then they disappear. So from a respondent standpoint, the respondent has incurred a lot of costs, and we've seen this in a few situations, because now the respondent may want to get the tribunal constituted just for effectively two reasons. We want costs in an award that we can then enforce the costs related to that application, and then we also want this arbitration to be formally concluded by way of that final award on costs without the claimant's participation. So we've seen that a few times as well.
Okay, I mean, you would see this side of things only in India, particularly commonly, I suppose. Have you seen it outside India being done outside as Indian parties? I don't know, because this kind of things used to be quite common when we were in the bar.
Well, I think that what I have often said is that in terms of sophistication and I think novel things that are being done in arbitration, there are no better lawyers than Indian lawyers. And I think that's why it's important to have an institution, because some of the most creative arguments that can, especially from the respondent side, have an impact on an arbitration certainly come from Indian lawyers.
Okay, so I have another question. This is from my lawyer friend. So his question, I think you were actually referring to this. So aren't there due process concerns when you do an expedited procedure? Enhanced due process concerns, and like, do you allow disclosure, discovery to the same extent as you do in a normal procedure? These things would be different, right?
Yeah, yeah, and I think that's so. So I guess there's two phases to that. So the first is like if we're deciding an expedited procedure, can this arbitration be run fairly in 6 months? So if we don't have all the information, because this is prior to the constitution of the tribunal, this could be, say, 14 days after the notice is filed. Then the next phase is the tribunal. So the tribunal, say, from a discovery standpoint, is the tribunal has to figure out the procedural schedule. So if there's protracted discovery that the tribunal thinks is allowable, so, and if you're getting into very complex document requests, then SIAC has probably made a mistake by allowing it to be on the expedited procedure. That means that we've somehow misread what this case is really about. And I guess fortunately there, you have a couple avenues to take the case off expedited procedure. So you have the new ability for the tribunal to consult with the registrar and say that the case is no longer going to be conducted in accordance with the expedited procedure. But because we're in an academic setting and we can have a bit of fun running different scenarios, what happens if you take a case off the expedited procedure and you've already taken it from a 3-member tribunal to a sole arbitrator tribunal? So we make clear in the rules that the same tribunal that was constituted will continue to conduct the case, but that starts to be a bit of an issue. So in that situation, we'd probably use the extension of time, so that you're extending the time rather than formally taking it off the expedited procedure.
Okay, so I have this question. This is a technical question because you referred this, that the manifest standard for early dismissal has been brought about from ICSID. But then ICSID things are different. Like ICSID, if the tribunal denies jurisdiction, all it happens that you cannot get an investment award, but you are still you can get a commercial arbitration or remedy before the home court.
Yeah.
But when you are rejecting somebody's case on that, aren't you effectively non-suiting the him? Because what is the other remedy then? I mean, isn't it a threshold too high?
Yeah, so I mean, if you're talking about jurisdiction, so you effectively have 3 different standards, and they may not always be in the same order. So you have the prima facie standard, so that's the application that goes to the institution. So that is about right there. Then you have the manifest standard that's presumably there, and then a jurisdictional objection proper. But because it's not time bound, technically a party that was unsuccessful in a jurisdictional objection under the regular channel could way after then be making effectively a jurisdictional objection based on the manifest standard. That would have no chance of being successful. But it is a bit of an issue, and that's why we've got the discretion, I suppose, with the two-stage test. Now, in terms of the investment jurisprudence being brought in, now certainly a tribunal is not bound by this authority. But I think what is interesting is that we're now developing our own jurisprudence. And so I have elements now. I don't have an opinion because I work at an institution. If you're doing it on the base of manifest lack of legal merit, I think a very prudent way to do it is, even if we take your facts at their highest, is this good or bad in law? So we're assuming all of your facts are true, and that's sort of how we see tribunals kind of workshopping it. So I don't think that SIAC tribunals are bound by any of the ICSID jurisprudence.
Okay, so basically it's an ICSID-inspired jurisprudence, not importation of ICSID jurisprudence, right? So that's how you'll put it.
Yeah, absolutely.
Okay, so the last question, this is also a student request. You have mentioned 2 cases from, I think, the Shanghai court, and one is the Noble Resources. This is a Singapore decision, right?
Noble Resources, Shanghai Intermediate Court, but SIAC arbitration.
Okay, so can you just give us the citation? I mean, this looks like an interesting decision.
Yeah, so we've got Noble Resources, that's Shanghai Intermediate Court. I'm not sure if I've got the full site offhand. And then you've got two more, AQZ and ARA, and then BXS and BXT.
Okay. So maybe if you can just email me. So that was a student request that I had. And last, there is a question. I don't think it's actually connected to the presentation, but in the loan agreement with the banks are the dominating party, draft arbitration clause stating arbitration will be appointed by the bank, some employee the bank being dominating party. So he's basically asking if how would you treat as a unilateral appointment clause? Would you give effect to it?
Oh, I mean, we could spend a whole session on that. Yeah, and you still do see these. So that becomes another situation of an express term versus an incorporated term. So if you had a situation where one party got to appoint all three arbitrators from a natural justice standpoint, what is the institution going to do with that? So party autonomy, but is party autonomy absolute? So it's an interesting exercise. It depends a bit on the language of the clause, but yeah, very interesting issue. And I should just go back. I just quickly pulled up the full site on Noble Resources. So Noble Resources International and Shanghai Good Credit International Trade Co. 2016 decision, Shanghai Intermediate Court.
So there are interesting cases actually coming from China, and I have been noting it for some time now because earlier we did not actually look into China for jurisprudence. Yeah. But yes, this looks interesting and we'll have to follow this. No, so I think this is the last question I would take. If the countries have their own legislation, so if you have a legislation in the applicable law, or where the Lex 40 is, so will that override the Singapore rules, or how will you look at it?
So I suppose it depends on where the seat is, and this is one of the complications. And one of my favorite things about the Singapore Act is the Singapore Act in Section 15A makes very clear the interaction of legislative provisions versus rules agreed by the parties. So where it's silent or where it allows the parties to otherwise agree. And I mean, I guess maybe to give an instructive example, I'll return to the right to a hearing under the model law. So yeah. If an institution says no hearings necessary, but the relevant legislation says hearings, if one party requests, the tribunal is bound to have a hearing. I'm not sure how successful those institutional rules would be by saying that they could override a legislative provision unless that legislative provision allowed the parties to make their own arrangements.
Okay.
And you could also, just to add on to that, I mean, sometimes referencing, say, the great George Berman and his Twilight issues from Columbia University is because the position might be different in different jurisdictions. So you could have a case, say you had a case in an SIC arbitration with a Singapore seat where there was a success fee, and say before, and the tribunal, and it was a party from China where success fee wouldn't be against public policy. How does the tribunal workshop that? So if the law firm had signed up so that we get 30% of the eventual award, what do they do? So that's likely against public policy in Singapore, but would be enforceable in China. So there's lots of these, I think, sort of gaps and potentially conflicting legislation that tribunals have to deal with. That's where you're happy that you're the institution and not the tribunal having to decide these tricky issues.
Okay. So I think I had a question about this standard of relief. So it seems to me, like if you read Gary Bond, of course, he has advocated this transnational test. So yeah. I can completely understand that he would do it here as well. But is it something acceptable to all national courts?
No, I think the short answer is no. That wouldn't be acceptable to all national courts. But what is going to be done with that emergency arbitrator order, anyways? So say if we had some faraway country and they have a completely different national local court standard, if you took that there with the transnational test, there's not much that court is going to be able to do with that. But in many jurisdictions, parties are going to be reliant on voluntary compliance in any event.
Okay. So any other questions that you have? Some of you are sending. Yeah. So Kevin, thank you so much. It was a great, you had given a great presentation. It was wonderful. You have given a presentation about the expanding frontiers of arbitration, actually. I mean, arbitration law is not static. Every year, the arbitration I teach, there is something different. So this is the beauty of it, that it's a growing body, it's a growing organism, right? And the institutions are at the forefront of this growth. And so thank you again for joining us. I think somebody is asking a very late question. How is transparency ensured? How is transparency ensured in emergency arbitration? Is that what your question? Yes, I think that is the question.
I think well, maybe generally, and that's a very important question. And so I actually, to me, I bifurcate that. There's two kinds of transparency, and let's just stick to commercial arbitration. So there's transparency in terms of public transparency, and then there's transparency within the proceedings. So you see some of the things that ICC is doing, publicizing arbitrator appointments, law firms, awards, redacted awards, unless the parties are opting out. So this is public transparency. And then there's internal transparency. So communicating reasons for the decision from the institution. I think what we've done at SIAC, we want to build arbitration jurisprudence, and you need public transparency for that. But at the same time, the confidentiality provisions in the SIAC rules are pretty strong, and parties in Asia Pacific, confidentiality is important to them. And again, leveraging off the academic setting here, one thing that's interesting is I think everyone wants transparency for someone else's case, because we all love arbitration. So if it's not your case, but what we found when we're trying to solicit consent from the parties is parties on their own case, they don't want to publish their own redacted award. They want it from someone else's case. So there's a balance here to protecting confidentiality and then also building arbitration jurisprudence. And institutions are at kind of have to lead the way on that. And I think institutions are doing quite well.
Okay. So thank you, Kevin. That's all we have time for, folks. No more questions. Thank you, Kevin, so much. We would love to have you again sometimes. And we had really a wonderful session. Thank you once again. So this brings us end to the first lecture in our SIAC-CADR lecture series of emergent issues in international commercial arbitration. So Kevin, thank you so much once again. And thank you, our IT team, for being so supportive. And thank you, Niharika. And thank you, the students, for participating. See you again. Bye.
Thank you.
Have a great day. Bye.
My pleasure.